Welcome to this adult education senior university session, Securing Your Legacy, Essential Strategies for Estate and Wealth Planning. Our presenter today is April Ratcliff. She is a senior personal trust officer with Horizon Bank, and we're very glad to have her with us today.
So my name is April Ratcliff. I am a trust officer with Horizon Bank. And what that means in large part is that I do relationship management for our clients who have wealth accounts. And wealth accounts could be anything from a retirement account, a trust fund, a guardianship estate, any account that's been opened in the Lake County area with our wealth division at the bank. Prior to coming to Horizon Bank, I was an estate planning attorney for 9 years. And so we're going to go through some of what I believe to be the most essential basics of estate planning, as well as some strategies for wealth planning. Because in addition to planning your estate, it's very important that you can fund your estate. You could have the greatest plan in the world, but if you're not appropriately managing your assets and putting plans into place, your plan won't work, right? You won't have sufficient funds to make your estate plan a reality. The basics, what is estate planning, right? Your estate is everything you own at the time of your death. So your estate comprises of everything that you own, right, at the time of your death. It's your house, your bank accounts, even including all of the personal property in your home, your cars, your investments. All of that comprises your estate. And when you pass away without an estate plan, it's going to just go in accordance with the laws of the state where you live. Otherwise, you can put together a plan using a will, a trust, or any other number of legal documents to indicate how you want your assets to pass when you pass away, right? And that includes how your debts will be paid, how taxes will be paid. If you have small children or grandchildren that you're responsible for, who's going to be their guardian, who's going to be responsible for taking care of their person, who's going to be responsible for taking care of their money. It also covers managing your care while you're incapacitated. A lot of times we think about, oh, my estate plan, and we put a will together, we put a trust together, and it's like, oh, I have my affairs in order, but we don't have anything in place if you should get sick. And if you get sick without the proper plan in place, you could still end up in probate. If you've gone through your whole estate plan to avoid probate or what have you, you could still end up in probate court in a guardianship case. Because for a disabled adult, if you don't have a plan in place to say who's going to make my medical decisions, who's going to make my financial decisions, then the court will decide that for you. So all of that is a big part of estate planning. The most common documents we use and that we see in estate planning are wills, trusts, power of attorney, and medical directives, right? A will is straightforward. I give X to Y. Upon my death, I give my laptop to my sister, right? Very straightforward. But straightforward is not bad. I think wills get a bad rap a little bit, but they are a very useful tool. If you do have minor children or grandchildren that you are responsible for, the will is the only document in which you can legally put forth a proposed guardian for that child in the event of your passing. So even if you opt for a trust-based estate plan, you still want a will to go along with it to spell out what's going to happen with your minor children. Trusts are insanely popular right now because everyone wants to avoid the cost and time of going through the probate courts. So there are a number of types of trusts. This is just a list of 3. Living trusts, that's the most common. It is revocable. You can change it, you can amend it. And it works where the trust can own assets while you're alive and you have full control over all of your assets that you put in the trust during your lifetime. And then when you die, you've nominated a successor trustee who's going to then manage your assets in accordance with the trust. And that could be paying out of your trust, or that could be maintaining assets within the trust for the benefit of your children, grandchildren, whoever you designate. The other probably second most popular type of trust is irrevocable trust. Now, these trusts offer tax benefits and asset protection in a way that living trusts do not. However, they are irrevocable. Once you've got those terms in place, they're locked in, right? So it's not nearly as flexible or as fluid as, let's say, a living trust. We also see a lot of trusts set up for charitable giving when you pass away. And it's not on this slide, but something very popular, at least in Illinois, is a land trust. Land trusts are trusts that are specific to real estate. You can put a piece of property in a land trust to keep it out of the probate courts. And the land trust would have a trustee, just like all of these trusts would, who decides who inherits that house when you pass away. Power of attorney, I feel like those are pretty self-explanatory. You are authorizing a person to act on your behalf. You're authorizing someone to make your decisions for you. And that can be healthcare decisions, financial decisions. Those are very customizable documents where you can spell out how much authority you want to transfer, for how long do you want to transfer that authority. So they're customizable in both duration and in scope of authority that's passed to another person. A living will or medical directive is it's an interesting legal document because it's unlike the others. It spells out specifically what you want to see happen in the event you are incapacitated. You can spell out what medical care you want to receive expressly. I want this, 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 and that. You can say what you don't want to receive. I don't want blood transfusions. I don't want I'm okay with some life support, but I don't want to be on a ventilator. You can get very specific with your medical directives in comparison to, say, let's say a power of attorney for healthcare. With the medical directive, you spell out in very particular terms, what do you want to have happen? If I'm pregnant, keep me alive until my baby is born. I want this kind of life-saving care, but I don't want this kind of life-saving care. And then, of course, also there are medical directives like a DNR. I don't want any life-saving care. I don't even want CPR. If I'm gone, just let me go, right? So medical directives get as detailed as you would like them to be, whereas a power of attorney is more a broad sweeping transfer of authority. I put together a healthcare power of attorney, and now my mom can make all of my medical decisions for me, and it's up to her to decide what treatment I will and won't receive. Wanted to talk a little bit with you guys about avoiding probate. When I was practicing law, so many, and even some at the bank, people come in all the time and say, I want to avoid probate. I don't want to go to probate. And they don't even know what that means or what it is, right? And so probate is a division of the court that handles the assets of a person, right? And so in estate planning, it is specifically the process of distributing a deceased person's assets according to their will or the state law. But we also have probate court when you can't make decisions for yourself. So minors have minor guardianship through the probate court because they're too young to make decisions for themselves. Adults with disabilities who no longer have capacity to make their own decisions, if they failed to put together powers of attorney and powers of appointment indicating who was going to make their decisions, the court will step in and open a probate estate to manage those assets on their behalf as well. Probate is very expensive. On average, legal fees can be $7,000, $8,000 up to 4% of the total value of your estate. The larger the estate, the more expensive it can be. The more your family fights, the more expensive it can be, right? So a simple uncontested estate where everybody's in agreement, the will is clear, I give X to Y and there's no question, is going to be a lot cheaper than when the family is fighting. Well, no, mom said I could have this, but she left it to me and it's in my care, or if they contest the will, right? This will's no good anyway. My dad didn't want this will in court. We shouldn't be bound by it. And so the family can sort of go back and forth, and probate can take years. The baseline for a deceased estate is about 14 months, but many estates go well beyond the 14 months. And that just depends on a number of factors. How quickly do the assets sell and liquidate? How well is the family working together? How quickly can the court appoint someone, right? Because if you didn't appoint someone in your estate plan, the court's going to pick someone, and you could get this sister petition and a brother petition and another person, and now we've got to go and have a trial on who's the best person to manage your assets because you didn't put a plan in place. Um, it's also public. Probate is a matter of public record, right? It invades your family's privacy. Wills are always filed in the courts of record, and cases in court are public. You can go into any courthouse and pull a file. All you need is a driver's license. You don't have to be an attorney or anything like that, and you can get access to any and all of the public documents that are contained in that file. And so by avoiding probate, you do allow your family a greater degree of privacy in the administration of your assets. Probate also pays your bills, right? They allow for creditor claims. Creditors, you owe people money, they can file claims in probate court. And those claims, there's like a hierarchy of claims, secured debt, unsecured debt. We're not going to get into all of that, but there's a hierarchy and the bills are paid in order. Um, and then your family inherits after those claims are paid. So those bills are going to come off the top, provided the claims are approved by the court. So it is the best to avoid the probate process whenever possible. And you do that by putting together a proper estate plan. Now, probate is not always a bad thing. Sometimes the will is a good thing. If you know that your family might need judicial oversight. And what I mean is I have seen the the negative side of being outside of probate. I've seen people put together a trust, and now the aunt is in charge of the trust. She's the trustee, and she is misappropriating the money. Um, she's spending it up before the children can inherit it, and in that instance, the children's only recourse would be to sue her for, breach of fiduciary duty. Whereas in the probate court, anyone who's administering money for the benefit of another has to have insurance on the money. We have to post a surety bond, and that money is insured. And so the family can file claims if someone is stealing and get that money back. So it's not always great, right, to be outside of the court. But if everybody and everything is on the up and up, the ideal situation is to save your family time, money, and resources by drafting a plan that's going to keep you outside of the probate court. Wealth planning, on the flip side, is really, sorry. Wealth planning, on the other side of things, is the process of holistically managing all of your financial resources, usually at the individual level, but sometimes we can do wealth management and wealth planning at the family level as well over an extended time, right? So you're planning your money today that's going to take care of you 30 years from now, or you're planting seeds right now that are going to take care, and that money is going to take care of your children and your children's children. The aim is always to align the financial decisions that you are making today with your long-term objectives. If you want to be able to gift your children hundreds of thousands of dollars after you pass away, well, then you've got to that money's got to come from somewhere. And so we've got to make those decisions now so that our children and our grandchildren have those resources in the future. And it's not just necessarily the next generation, but also every stage of your life. You want to take care of your money today so that if you have to pay for nursing home care 20, 30 years from now, you have the option to afford quality long-term care. I feel like everyone has heard nightmare stories about terrible nursing homes and things like that. And so planning for your eventual long-term care, and hopefully you never need it, is a very important part of the wealth planning, a holistic wealth planning, right, for all of your finances. But not only just for your care, but your standard of living. You want to consider, how do I want to live during my retirement? What's my standard of living? Have I saved enough in my retirement to be able to afford to live comfortably in retirement and not have to alter my standard of living? And so things that you want to do in looking at your assets is embracing a long-term investment strategy, putting away money that you can realistically leave in the stock market, leave in an investment account, leave in a long-term investment so that it has time to grow. So when you need it, it has appreciated, it's going to be enough to cover what you need. It's very important to diversify your investments. Don't put all your eggs in one basket, right? You want to have some money in fixed income, some money in the stock market, some money maybe in CDs, some money in an annuity. You want to have a very diverse portfolio so that if the stocks are down, you're still making money over here on your fixed income, or you've got a guaranteed rate of return on your annuity or your CD so that you're still making money as markets fluctuate. It's very important to purchase sufficient life insurance. Lots of people fund their trusts and fund their whole estates with just life insurance. You can buy a life insurance policy and make it payable to your trust. So that when you pass away, the trust is going to inherit 750,000, $1 million, right? And now the trust and your trustee has ample resources to make the things that you've spelled out in your trust come to pass. But the sufficiency of your life insurance is determined by your goals. How much are you trying to have for your children, for your grandchildren? What do you want them to have the money for? How much control do you want to have over that money from beyond the grave? And in making these sorts of decisions, it's very important to sit down with an estate planning attorney. At Horizon, we offer estate reviews, but we cannot advise you as attorneys, right? I'm an attorney by trade, but I can't be your attorney. So if you meet with an attorney, you bring in your documents, I can look at them and say, okay, this does what you want it to do. Maybe you want to go back and talk to the attorney. Maybe it's not doing exactly what you thought, because it is complicated legal jargon. But it's important to have someone, have a team of someone's working on that plan for your benefit. Okay. And you want to be updating your estate planning or your financial planning documents at least every 3 to 5 years, but also as life changes. As you have life changes, you get married, you get divorced, you have kids, you got a new grandbaby. Any of those things might change how you want your money to pass. And so, as your life and your family change, you want to make sure that you're updating your will, you're updating your trust, that you've sat down with your financial advisor to talk about what are those new family members or the removal of family members? What does that mean for my financial future? Um, I put this in here about estate taxes. Most of us are not going to pay estate taxes, but maybe you will. Estates under 13,610,000 are exempt from estate tax. Indiana has no estate tax or inheritance tax at the state level. And they haven't for a long time. But there are things that you can do if you do have a large estate to start minimizing your estate taxing. You can maximize your lifetime gifts to your children. You can put assets into an irrevocable trust. You can create residence trust intention and other like intentionally defective grantor trusts. And I don't want this to be like a class on every type of trust, but there are a number of different estate planning vehicles that you can create specifically geared at reducing estate taxes and generation skipping taxes as well. Um, in terms of planning for your incapacity, in the event that you are unable to make your own financial decisions, you're unable to make your own healthcare decisions, I personally recommend at minimum everyone has a power of attorney for their finances and a power of attorney for their healthcare. If you want to get into the more nitty gritty of things, great. But those two things are going to keep you out of probate guardianship court. If you've nominated someone to make your financial decisions and you've nominated someone to make your healthcare decisions, then you don't need a court to step in and appoint someone to make decisions for you. And it's important to have those documents no matter how old or young you are. If you have children, if you own a home, if you have assets in the bank, you should have those documents in place because anything could happen. You get in a car accident tomorrow. You want to make sure that someone's advocating for you. And it's the person that you want advocating for you, someone that you've discussed your healthcare concerns with, who is familiar with your finances, someone who you trust not to exploit you financially. And it's a sad thing to say, but right elder abuse, financial abuse, all of those things happen even with the most careful of plans. So it's very important to make sure that you are nominating people that you can trust. Oh, to govern your affairs in the event that you cannot. Um, we talked a little bit about living wills. Like I said, that allows you to get very specific with respect to your health care. It's great if you could have one, but it's not as important as nominating someone to make those healthcare decisions for you. You don't want it up to the doctors if you're going to receive this care or that care or what types of life support you might end up on. It could just be very different than what you would choose for yourself. So it's important that you take the time to spell it out, put it on paper. I would say the biggest mistake, like common mistakes and pitfalls in estate planning and financial planning is procrastination. People think, oh, well, I am in my 30s, I'm in my 40s, I'm in my 50s, I have time. But we never know what's going to happen. People die in their 20s, people die in their 30s, people die every day, people get sick, accidents happen, right? And I'm not trying to be negative, but that's the reality of life. The longer you put off drafting your will, the longer you put off meeting with a financial advisor to review and making sure that you have everything in order, the only person you're hurting is yourself. Right? If you sit down early and make your financial plan as early as today, right? Today is always the best day to start. Um, then you've set yourself up for success 20, 30 years from now. If you put your estate plan in place today, then you don't have to worry about what's going to happen to my stuff tomorrow. If your healthcare power of attorney is in place today, you don't have to worry, well, if I get in a car accident tomorrow, what's going to happen? Is there anyone who's going to be able to pay the mortgage for me? Is there anyone who's going to be able to go to the bank and make sure all of my bills are current while I'm in rehab getting better? And so people put it off. Other mistakes, not assessing your long-term goals, not looking at what standard of living do I want to be at during retirement, estimating the cost of long-term care and ensuring there's sufficient assets to cover those potential needs. And nobody wants to go to a nursing home. No one wants to think about themselves disabled. No one wants to think about these things. And I understand it, but at the same time, you kind of got to go worst case scenario. Worst case scenario, if I am ill, I can't take care of myself, it's going to be too much for my children. Long-term care is going to run me $6,000 to $8,000 a month. I need at least X number of years based on my age, right? You want to do the work to calculate. And of course, it's going to be an estimate, but you want to at least estimate what you think you'll need to cover your bases so that when you are older, the money is there. You don't want to end up in a state-run nursing home with just Medicaid to take care of you for a number of reasons. Those facilities are not often the best quality of care, but not only that, Medicaid, if they pay for your long-term care, they can come back and take your house. So now your largest asset that maybe all you had to pass on was your real estate to your children has a state lien for $160,000 against it because Medicaid wants to recoup their money that they spent while you were in long-term care. So it's very important that you anticipate all of your potential needs in determining how much life insurance, how much long-term care insurance, how much coverage do I need. The other pitfall is often failing to regularly update your documents. As I mentioned, 3 to 5 years is the ideal time to go in and update these things, but also as your life and situations change. And I say that my own father, when he passed, he was so guilty of that. His will was from 1989 and he passed away in 2020. It named guardians for me and my sister. It referenced a house they didn't own anymore, right? So it's just so important that as your circumstances change, as you gain and lose assets, as you gain and lose family members, that you are taking the time to update it so that your family is not lost when you pass away. And then, of course, lastly, not making a plan at all. So many people in Illinois and Indiana and all over the country die intestate with no will, no trust, no nothing. And now it's up to the courts to divide your assets basically as the state sees fit. We have every state has what's called intestate succession. They spell out a line of succession for you when you don't do it yourself. And those might not be the relatives that you want to inherit. It could be, but there's no guarantees. Long-term care concerns. We've covered a lot of this information, just assessing your long-term care concerns. But something to put on your mind is if you need long-term care insurance, many people do not have enough saved for the event in the event that they were to go into a long-term care facility. There are a lot of insurance products that you can purchase that, life insurance with long-term care riders, annuities with long-term care benefits, straight long-term, traditional long-term care insurance that could reimburse for care in your home, in a nursing home, or in assisted living. And so I just wanted to kind of reiterate the importance of making sure you have something in place, because the government benefits that would be provided to you for free with respect to long-term care um, come at a significant cost. The other thing I wanted to talk about a little bit with respect to wealth management and wealth planning is retirement savings considerations. We talked a little bit about what standard of living do you want to have during your retirement? You don't want to be, how much are your bills? You want to make sure whatever income is coming in is going to be enough to cover your bills and to allow you to live comfortably. You want to evaluate all of the sources of income that will be available to you during retirement. Do you have a 401k? Do you have a pension? Do you have an IRA? Do you have an annuity that's got lifetime payments? There are so many different vehicles that you can set up for yourself to supplement the retirement account you may have from work to allow you to live comfortably. Many people have 401ks, pensions, and stuff like that, but sometimes those accounts don't pay enough monthly to cover everything, and you don't want to find yourself in a position where you're retired and now on a fixed income and you can't afford your mortgage, you can't afford to live comfortably. And everything is just tight. You want to make sure that you are properly contributing if you're still working. If you're over age 50, you want to be making catch-up contributions into your retirement accounts to maximize the federal limits on those accounts so that you are putting as much money as possible into your retirement savings vehicles. And it really doesn't matter what type of retirement savings vehicle you opt for. The ultimate goal is having enough regular monthly income or having enough money saved so that you can maintain a comfortable standard of living for yourself, and that you're not feeling the pinch when your ability to earn money has affected by retirement. So yeah, we're at the end. So I know I saw about 10 questions in the chat. There were quite a few comments and questions. And I know we have questions in the room. So just go for it. We'll just go around. So Crystal asks, would I put my house in a living trust or a land trust? And so I'll be candid with you. My house is in a living trust, but that doesn't mean that a land trust is not a better option. I think it really depends. A land trust is a great option for people who don't have a lot of other assets. Your home is your primary resource and it's your major concern. And you would like to have your house protected for the next generation. I have young children, so I have my home in a living trust because I have all of my life insurance payable to my living trust, and I've spelled out what I want that money to do for my children. And you can get very particular with your living trust. I want enough money to be so they can stay in private school. I want gifts if I'm not there when they get married for them to get a gift from their mother and their father. I want very specific things. And so a living trust is going to allow me the flexibility to articulate what I want to happen to both my real estate and my money and my other assets. A land trust is real estate specific. I can only say my house to my two children with my mother as conservator, but I can't spell out the rest of my wishes. And so it really depends. And this is for all different estate planning documents. What you need in your estate depends on what you own and what you want to see happen for your future. If all your kids are grown, your grandkids are grown, maybe you don't need a living trust that spells out how every dollar is accounted for. And you just need a land trust to keep your house from falling into probate court. That's really something you'd want to discuss with an attorney when you sat down for an estate planning review meeting. I believe the question was, if I have no family living, can I place my assets into my business? Um, and so you could put your assets into your business if that suits you, but then now you would need a business succession plan, right? So then you would still need a plan that spells out, well, what's going to happen with your business assets, who's going to inherit, and how does ownership and management of the business pass on? What often happens when people don't have family, they nominate friends. You can nominate banks. Horizon Bank will serve as your executor. We serve as trustee, right? I'm a trust officer for the bank. So I manage trusts on behalf of a large number of families here in Lake County, where you can appoint a corporate trustee to manage your assets or to serve as the executor of your will or the successor trustee of your trust. We even serve as guardian for persons with disabilities and minors in instances where your assets need to be governed and you don't have a relative to do so. But the business, putting assets into a business is not a bad idea. It just creates now the need for business succession planning, putting things into your business without spelling out, well, now what happens to the business in the event that I can't no longer manage the business or I pass away. You're still going, the business itself could end up in probate, right? If it's personal property, if it's an LLC or something like that, well, now your nearest living relative, your next of kin, is going to be in court trying to get a court order to determine what happens with those business assets. Is an out-of-state beneficiary subject to Indiana estate tax? Is that the question? Or the state of their residency? Typically, it's going to be the state where the estate is located, right? So if the assets of the estate are all here in Indiana, it's going to be governed by Indiana law. And Indiana taxes where Indiana has no state tax, but there would still be federal estate tax if you met the threshold. On the flip side, in Illinois, we do have estate taxes if your estate is over $4 million. It's a much lower threshold than the federal threshold. And so for Illinois estates, those estates that are opened there are then governed by the law of the state of Illinois. And the same would typically be true here in Indiana, that you would be governed by the law where the estate is located. Her question was, if you are considering relocation, should you wait until you've relocated to do your estate planning or do it now before you move? In almost all 50 states, if you have a valid estate plan in the state where you live, it is going to be binding even when you move. Okay, so if you decide to put together your estate plan and you deed your home into trust, but you sell it out of the trust and you move to another state, the only thing that happens with respect to that real estate is the gift of real estate would lapse. Same thing if you just had a will. If I have a will and I give my Hyundai Tucson to my sister, well, if I've sold that car by the time I pass away, the gift is deemed to have lapsed and she doesn't get the car, right? Okay, so her question for the people on Zoom was asking about payable on death deeds. And I think what you mean is transferable on death. Okay, so transfer on death deeds or transfer on death instruments, as they're called in some states, are a great estate planning tool if all you have is your house. They are typically very affordable, very efficient. But they do have their limitations, right? A transfer on death deed says, upon my death, I give my house to this person. And that gets recorded at the county level, at the recorder of deeds. And when you die, whoever you've left the house to brings a certified copy of your death certificate and that recorded transfer on death instrument over to the recorder of deeds. They give them an affidavit. They fill out the affidavit and pay the recording cost for the affidavit. And the house is now in their name. It's a very simple, straightforward transfer. And it's very beneficial if everyone you're leaving your home to, if you're leaving your house to just one or two people, and everyone's an adult, right? You can't leave real estate to a child via transfer on death instrument, and a transfer on death is instrument or deed is limited to your primary residence. So if you own multiple pieces of real estate, you would need to do something different. But if the only piece of real estate um, that's of your concern with respect to estate planning is your primary residence, then you could pass that property without the need of probate very efficiently with a transfer on death instrument. So her question was, if you've named a pay on death beneficiary on all of your accounts, do you need to do anything else to ensure that your assets don't go to probate? And with respect to those accounts and those assets, no, you do not. If you name a pay on death beneficiary on all of your investment accounts, your checking account, your savings account, that money is going to transfer automatically to the people that you've nominated when they present proper identification and a certified death certificate to the bank or other financial institution. Those are obviously limited to the account, right? So I go and I name pay on death beneficiary on all my accounts at Horizon. That's only valid at Horizon. If I open another account at Bank of America, that account is potentially subject to probate, provided that it's also over the threshold. But if you've gone through every account that you have and named beneficiaries on all of your accounts, then all of your financial assets are going to pass in accordance with those beneficiary designations that you've made. You don't have to take any additional steps to keep those monies out of probate. Her question was, if all she has is financial liquid assets and she named beneficiaries on every account, all of her accounts would then be covered. And yes, that is true. But again, it is with limitations. If you named someone that is not 18 years old, then you're back in probate court, because giving money to a minor means their parent now has to create a minor guardianship account in probate for that minor to inherit money. It's also a straight gift, much like with a will. If I name you pay on death beneficiary for my account, you get all of the money without any stipulations, right? Whereas in a trust, you can put stipulations. I am going to give you $100,000 upon the completion of college. And if you don't go to college, I'm going to give this money to charity. You can use your money to incentivize the behaviors you want to see. I've also had people use money and gifts to sort of discourage things they didn't want to see. I had grandparents who left each of their grandsons $300,000, but they wanted it conditioned on if they ever fell into addiction or, substance abuse, that they would be subject to regular, testing by the appointed trustee in order to continue to inherit, with the goal of making sure that their hard-earned money didn't get spent out in the streets if one of their grandsons ever fell into those sort of hard times. So you have a lot of control and flexibility, and you're not limited with respect to minors when you use a trust. But there's nothing wrong with just naming beneficiaries if everyone you're giving your money to is grown and you just want them to have it without any caveats. Her question was, if I've already named a pay on death beneficiary and I want to change it, how do I do that? So at Horizon, it's as simple as coming in and signing a form. For most financial institutions, it's going to be as simple as signing a form. For wealth accounts, you designate your beneficiary. You do need their date of birth, their social security number, and their address. But generally speaking, if it's an investment account, you can call your investment advisor and say, hey, I need to make a change to my beneficiary. Oftentimes they will mail you a form to have you fill out. Some Sometimes you can do it online, but it is usually a single form that you fill out with whatever financial institution is holding your account. And once that form is filled out, the update has taken place. It's just that simple. Okay. So I don't know how sharing what I've seen would protect anyone, but certainly some things to look out for, or things that I have seen. I have seen in court situations where a person was named the administrator over someone's estate. That's the same thing as being an executor. It just means you didn't have a will. The court picked you. And that person then spent $70,000 that belonged to someone else, right? It belonged to a little girl. And she felt like, well, I could spend this money. They gave it to me. And the court held her accountable. Again, through the court system, we have surety bonds in place, and the family of the young girl was able to open a minor probate estate and file a claim with the surety company and get their money back. And the surety company went after that lady for those funds. But I've also seen people not name the wrong person in their financial POA, or not putting in sufficient limits on your power of attorney. So a power of attorney document is broad sweeping. If I put together financial power of attorney, it's going to give you access to all of my money, my real estate. It's going to give you access to all of my property in every shape and kind, unless I put limits in. And so there have been instances where people are spending the money of the principal, the person who nominated them, instead of paying that person's bills and managing their finances for their benefit while they were laid in the hospital, they wipe them out. I've seen people sell a property with power of attorney that the person did not want them to sell, but they didn't put in those limits. And with the power of attorney document, you can limit it. You can say no real estate transactions. Don't touch my retirement. I had one lady, she had a lot of money in Walgreens stock. She had worked there 35 years. She expressly put in her power of attorney, you're not authorized to sell any of my Walgreens stock. She had saved it up to quite a considerable amount and was leaving that for her grandchildren. And she said, even if I'm in the hospital, that's their money. Don't touch it. And so failing to put in those sorts of safeguards. I've also seen things where people put in no cash withdrawals from my checking account. I don't advise that, because people are slick. If they're going to steal from you, they don't need a cash withdrawal. They can write themselves a check. They can spend your debt, use your debit card. The most important thing is that you are nominating a person or a company that is trustworthy, right? If you nominate the bank to serve as your guardian of your finances when you're unable to manage, we are legally bound, right? And all of your accounts are insured with us to make sure that we're not spending your money in a self-serving manner. Um, for the most part, most people do a great job. Most people name another person as executor of their will. They go into court and they do the right thing. They post a bond, they sell the assets, they give the money away for the most part, right? But you know your family better than anybody else. You know your friends better than anyone else. And that's why it's important to not just look at your family, right? If you know that your family has a troubled past, they have bad relationships with money, they're irresponsible, a trusted friend is a much better option to name as your power of attorney than, your son or daughter with a gambling addiction. I had a lady come in to update her trust, and she named Horizon as a successor trustee of her trust because one of her sons had a disability and the other had an addiction problem. And she was like, neither one of them is going to be capable of managing the affairs. And it's, better to pay to ensure the money is invested and will grow and be used for their benefit than to let them squander it. So it really depends. And I don't want people thinking like, oh, your family is out to get you. I don't mean it in that way. For the most part, probate court is largely uneventful. For the most part, people are doing the right thing in determining and distributing assets. But things do happen. The other thing to be mindful of is scams. There are email scams, text message scams that target senior citizens, even telephone scams, right? Where it seems like something legit, seems like something that is related to something that you're doing or some account that you may have. Always call and verify, right? If it's related to your financial accounts, call your financial advisor, call your bank branch manager. Get confirmation that things are what they say they are. If you get a text message that says you owe tolls, call the tollway. Find out, give them your driver, your what is it, your license plate, and they'll be able to tell you if you actually owe money. Most of the time, people on these like phishing scams are trying to get you to click a link or give up some information that they wouldn't be able to freely get in order to access your accounts and then take advantage of your finances. Her question was, are there documents that people can use to do their own will? And if so, what do they do with them? So, I mean, all you need to write a legally valid will is a computer. You can type out, this is my last will and testament, but now it has to be binding, right? And that's that's where an estate planning attorney or comes into play, right? Because every state has different requirements. I don't practice law, never have in the state of Indiana. But so in Illinois, a will must be in writing. It must be properly attested by two witnesses. Does not have to be notarized. A lot of people think it does, but it must be in writing, properly attested. It has certain things. People try to make video wills. Those are not valid in every state. So if you're going to write your own will, step one, look up what are the will requirements in my state. Because if you don't comply with those requirements, the court's going to throw your will out and you'll go through intestate succession. But you don't need any specific forms or anything like that. What I highly recommend over just winging it and doing it yourself, if you don't have funds for an estate planning attorney, there are services like LegalZoom and Rocket Lawyer where you can purchase the will package, put in your information, it will generate a will, and for a couple of dollars, you can have an attorney review it for you online. Now, no, the wills are not going to be as good as a will written for you, like specifically by an attorney. It's going to be fill in the blank, more or less, plug and play. But is it going to be legally binding? Is it going to be cost effective? Is it going to get the job done? Yes. I would exercise caution with a trust if I'm just being candid. A trust is a lengthy, complicated document. Often trusts have springing trust, meaning gifts that you make create other trusts within the trust, like sub-trust accounts. I don't know that you want a fill-in-the-blank trust. If you need a trust, it's worth the money. And if you don't have sufficient money funds to put together a trust-based estate plan, you probably don't need a trust. You probably can manage your affairs with something more simple. Her question for our Zoom crowd was, what determines whether or not you need a trust? Is it income or asset driven? Typically, it's going to be asset driven, right? Estate planning is not usually driven by your income, but not only your assets, but your goals. What do you want to do? My mother doesn't have a trust because her children are grown. She's leaving everything to me and my sister 50-50. She has a will for all of her personal property and her financial accounts, and she has a transfer on death instrument on her house. It's going to go to us at 50-50. Simple as that. I have a trust because I have young children and I want the money held in trust until they're adults. I don't want them to have minor guardianship estates, and I want to have control over that money. I want to say what it's for. And the only way for me to do that is to put it in a trust where I spell out to my trustee after I pass away, I want you to spend the money for this, 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 and that. I want you to have discretion with respect to their medical care, their education, things like that. And so it's always going to be personal. I think a lot of people hear about trust online and they think, oh, I need a trust, I need a trust, I need a trust. And it's just not true. A lot of people do not need a trust. A simple will, beneficial designations on your bank accounts, and a transfer on death instrument will cover all of your bases. But there are additional considerations when you have a family with young children. If you need to name a guardianship for a guardian for a minor to avoid, someone stepping in to take guardianship of those children. If you have funds that you want to have control over from the grave, if there's monies that you want invested for long-term growth, not just to provide for your children, but then you're on to your grandchildren. So estate planning is always going to be driven not just by your assets, but by your goals. If you just want to give what you have to your children as a straight gift, you don't typically need a trust.
April question, following up on the trust. Can a trust be contested?
So yes, but not as easily as like a will could be contested, and it depends on the type of trust. Um, so like an irrevocable trust is not likely to be subject to uh, being contested because those terms were binding and permanent the day you made them. Only they can only be changed or altered with a court order, and the trust itself cannot be revoked. But if you have a trust and perhaps your family believes there's a trust amendment out there somewhere, they could contest the administration of the existing trust document on the grounds that there were changes to the trust, that the trust document doesn't fully reflect all of the trust terms that have been adopted. But that's relatively rare situation. The question was, if your beneficiary moves, how important is it to change their address? Not the address is not the most important thing. Most of the time, it's going to be their name, so like for financial accounts, you're going to give their social security number, right? That's not going to change. Their date of birth is not going to change. They just need to explain that they've moved, right? Now on a transfer on death instrument that's recorded against the title, you may want to just make sure that they keep record of where they used to live, because that's not as easily updated. But usually it's about the other identifying factors. We recognize that people move all the time. So like at the bank for us, your social, your date of birth, and your full name need to match what's on the account. If you moved, that's not really here nor there. So your question was, are there pros or cons to naming two people as POA? Most states do not allow you to name two people at the same time to serve as POA. That's just not an option. You may nominate an agent, and then you can nominate successors if that person is unavailable. But in most states, you cannot name two people to serve under a single power of attorney document at the same time. If a financial institution goes out of business, typically they're bought out by someone else, right? And so like for example, with Horizon, we have accounts that we inherited from other banks that Horizon bought out, but we maintain responsibility for those assets, and we continue to be bound by the terms of the trust, even though the name of the bank has changed. So her question was, is it expensive to move from an irrevocable to a revocable trust? It's not necessarily expensive. It requires a court order to change the nature of a trust because there are tax consequences there in putting your assets into an irrevocable trust that don't apply to a revocable trust. And so if you were looking to completely change the nature of an irrevocable trust that's already in place and already funded, you would likely need a court order to do that. So no, you don't have to be a customer of Horizon Bank to come in to discuss your estate. But I don't know what you mean by start an estate. Again, I no longer offer estate planning services. I will review your estate plan and your financial plan, and I will point you in the right direction, right? But at Horizon, what I do is actually manage the estates for other people, right? As a trust officer, when Horizon Bank is named as trustee, I make those distributions pursuant to the trust. If Horizon is your financial guardian, I do your guardian accountings in the court. I make sure we go to court on your behalf and make sure your money is growing. So I cannot personally assist with estate planning beyond referring you out to an attorney who could assist you. Her question was, can your will be contested? Yes, absolutely. They could say it's not valid. They could say you were under duress and you were coerced when you wrote it. There are a number of different ways that they could challenge it. They could argue that you revoked it, right? In most states, if your will is destroyed or stricken, those provisions are deemed to be destroyed by you, the creator, right? So they could, for a number of reasons, contest your will. They could come and say, hey, I wasn't mentioned in that will. I'm a kid you didn't even know about. Here's my birth certificate. I'm contesting that will because it doesn't include me. Um, so her question was, what is the purpose of the will if it can be contested? Just because they contest it does not mean they will be successful, right? A judge determines if your will is valid and binding or not. The judge is going to determine, and in most cases, they're going to look to the four corners of the document, absent overwhelming proof, right? So if you've got a will and it's the original, it's been stamped and sealed by the Lake County Courthouse, and then you bring it to probate that will, someone who wants to contest that will, they bear the burden of proof to prove that what they are alleging is true. They would have to bring in sufficient evidence to overcome the document itself. And that's not an easy hurdle. Just because you can do it doesn't mean you will be successful in doing so.
If a will is lost, can I get a copy from my attorney's office?
So that depends on the attorney and it depends on the state, right? So I've never practiced law in Indiana, but in Illinois, attorneys have no duty to keep records. We don't have to keep your will. Now, most of them do, right? So if you lost your will, you could go to, or your mother's will or whatever, you lost your originals. Most of the time, you can go to the attorney's office and get a copy. But now you're running into trying to probate a copy where most state courts will require the original. And so now you bear the burden of proof in proving that this photocopy is legit, that it wasn't previously revoked or destroyed intentionally by the person who made that will. And so there's typically a full trial on that where you have to come in and testify, like what happened to the original. Okay, there was a house fire. I can show our house burned down. The will was in there. Nobody revoked it, right? But you'll have to bring in that kind of proof to the court to overcome the presumption of revocation. When the original will is lost, there is a presumption that it was revoked. Well, thank you all for coming and for attending online. And please feel free to connect with me if you have follow-up questions or if you would like for me to sit down with you and review your estate plan.